Be ready. Start. Government of State of Haryana on 23/1/1990 issued a notification under Section 4 of the Land Acquisition Act, hereinafter referred to as the Act to acquire 72.03 acres of land in village Rewadi and Dhelavas Tehsil and district Rewadi. In furtherance thereto, notification was issued under Section 6 of the Act on 22/1/1991. On actual measurement only, possession of 71.87 acres of land was taken by the government, which was acquired for a public purpose, namely for development and utilization of the land for residential and commercial purpose in Sector 3, Part 2, Rewadi. The land acquisition collector, after affording opportunity to the parties to put forward their objections, vide his award number 15 dated 25/3/1992, categorized the land of both the villages into three different categories and awarded the following compensation to the claimants of their lands. The claimants preferred references under Section 18 of the Land Acquisition Act, praying for enhancement of the amount of compensation awarded to them. 35 claimants had preferred the references before the learned additional district judge Rewadi, who vide his award dated 12/4/1994, after following the due process, enhanced the compensation payable to the claimants and altered the categorization of the land on the basis of nature of land and converted the same into three different blocks depending upon the location and potential of the land. The claimants felt dissatisfied from the award of the learned additional district judge, raising the plea that the compensation granted to them is liable to be considerably enhanced only on the basis of Exhibit P1, filed 36 regular first appeals praying for enhancement of compensation, while the state of Haryana preferred 35 appeals against the same judgment, praying for reduction in the amount of compensation awarded to the claimants. In other words, these 71 regular first appeals arise from the same judgment. Thus, it will be appropriate to deal and dispose of all these appeals by a common judgment. As already noticed, the judgment of the learned additional district judge in the present case was followed by the learned additional district judge in the case of J. Narayan as Exhibit PA. All these cases have been heard together by this court, and as such, it becomes relevant for the court to consider whether the claimants in both the cases should get the same compensation or different one. It has come in evidence that both the villages from the revenue estate of which the land has been acquired fall within the municipal limits of the Rewadi town. Furthermore, these two villages are closer to Rewari town than the other three villages whose lands have been acquired in the case of Jai Narayan. Thank you.